A lawsuit brought by Greg Abbott, Texas governor, and 11 other states against the Obama administration's policy on restroom access might shift the U.S. closer to a declaration on transgender rights by positioning the issue on a velocity for the Supreme Court. Conservative representatives from 11 states sued the federal government on Wednesday, May 25, 16 to overturn the directive, where transgender students will be permitted to use the restroom related to their gender identity rather of being required to use one related to gender assigned at birth. The governor Phil Bryant of Mississippi mentioned he plans to be a part of the lawsuit. The Supreme Court has never ruled on an important question of the lawsuit: does federal legal rights towards sex discrimination implement to transgender people? The plaintiffs chose an avenue that can get them to effective wins in lower courts. The lawsuit is anticipated to be listened to first by a delegate of Republican President George W. Bush, as well if there is an appeal by a conservative federal appeals court addressing Texas. The appeals court ruled in opposition to the Obama administration. The Supreme Court could possibly feel urged to occupy the issue simply because of a probable turmoil with a ruling a month ago from a federal appeals court in Virginia. This ruling amplified a transgender teen's lawsuit towards his school district. The Supreme Court is very likely to agree to hear a case whenever there is a split between diverse federal appeals courts, as well as a discord doesn't exist yet on transgender rights. The plaintiffs currently have incriminated the administration of President Barack Obama of overextending its authority and said the United States Congress, for all of the states, ought to set the policy of 2 conditions of federal law prohibits discrimination on the foundation of sex. They are Title VII of the Civil Rights Act of 1964, in which addresses employment, and Title IX of the Education Amendments of 1972. Jeremy Tedesco, senior counsel at the Alliance Defending Freedom, a conservative Christian legal group, mentioned that when Congress approved the Education Amendments, they didn't take into account that the law can one day be utilized for gender identity. Said, the administration's lawless interpretation ignores the will of Congress in enacting Title IX. It's a clear case of federal overreach. The Obama administration contended that the Education Amendments encircle discrimination centered on gender identity, which includes transgender status. A letter to school districts this month stated that the school's accessibility to federal money counts on their consent. The states that sued has 2 paths to victory. 1. The judgment that the Obama administration didn't adhere to correct process for creating new regulations which will leave the larger issue unsettled. 2. That its meaning of Title IX is sporadic with the law. Without having clear guidance from the courts, questions of transgender rights will continue to be open to interpretation by federal agencies, which indicates that an upcoming president can't take the contrary view of Obama. The Republican-controlled Congress possesses the power to conclude the dispute instantly, either in favor of transgender rights or against them. However, it has demonstrated few signs of operating, particularly with a Democrat, Obama, in the White House. Jennifer Levi, director of the Transgender Rights Project at GLBTQ Legal Advocates and Defenders, informed me that a sequence of options indicates that the courts are approaching to a considerably more substantial definition of sex discrimination. Federal organizations obviously have the capacity to translate civil rights laws when its application is unclear. Mrs. Levi also stated, to characterize the administration's position as extraordinary or overreaching shows a complete misunderstanding of what these agencies do. The states counterclaims in their lawsuit the fact that the federal agencies proceeded to go beyond simple interpretation of civil rights law and essentially developed brand new regulations that needs to have gone through the notice and comment procedure. The court can furthermore discover that the state's lawsuit was premature simply because the Obama administration hasn't migrated to cut off funding to any state or school district.